Hi everyone, I am Kavya, Assistant Professor of B.Com CA from KSR College of Arts and Science College, Women, Tiruchengodu. We have seen last company law for first to third unit. Now we are going to see the 4th and 5th unit. The 4th unit is Management and Administration. Management is the process of planning, organizing, directing and controlling the activities of an organization to achieve its objectives efficiently and effectively. In a company context, in a corporate setting, management refers to the board of the directors and senior executives who make decisions, implement policies and oversee day-to-day operations. Meanwhile, administration refers to the process of implementing policies and ensuring compliance with the law, regulation and organizational procedures. In a company context, administration is mainly concerned with procedural and regulatory aspects such as record keeping, statutory filing and ensuring legal compliance. Next is Board of Directors. Board of Directors, appointment and removal. Directors are appointed as per the Articles of Association or by the shareholders' resolution. Removal can be through a shareholder resolution, Section 169, Companies Act 2013 in India, or under disqualification classes. Disqualification, the examples are undischarged, insolvent, convicted of certain offences, failure to pay calls on shares, etc. Director identification number. This is a unique number assigned to each director to maintain transparency in appointments. Next is one-person company and insider trading. One-person company is the type of a company that can be formed by a single individual, that is, an individual or a sole shareholder and member. Introduced under the Companies Act 2013, India, to encourage the entrepreneurship with limited liability. Insider trading refers to the buying and selling of securities of a company by someone who has access to unpublished price-sensitive information, that is UPSI, about the company, that is called as insider trading. Next is Managing Director and Manager. Managing Director performs day-to-day management and appointed for a term. Manager may have some restricted powers and appointed as per the Companies Act. Next is Secretarial Audit and Administrative Aspects. Secretarial Audit complies with Companies Act and regulations conducted by practicing Company Secretary. Administrative aspects are statutory registers, filing, resolutions and meetings. Next is Unit 5. Winding up meaning is process of closing company affairs, realizing assets, paying liabilities, distributing surplus, governed by Companies Act. Next, modes of winding up. There are two types of winding up, that is compulsory winding up. Compulsory winding up is by tribunal or by NCTL, ordered by National Company Law Tribunal. Grounds included are company is unable to pay its debts, company has acted against the public interest, just and equitable reasons. Example, deadlock between members. Company's objects have been achieved or become impossible. These are the reasons for winding up of the compulsory winding up. Next is procedure. Now, how the compulsory winding up is done. The procedure for compulsory winding up is petition filed, NCTL hearing, winding up order and appointment of liquid. Modes of winding up is the second winding up is voluntary winding up, initiated by members or creditors without the tribunal intervention. Types are members voluntary winding up, creditors voluntary winding up. Members voluntary winding up is company is insolvent, declaration of solvency required, shareholders pass a special resolution to wind up. Creditors voluntary winding up is company is insolvent, creditors approve the winding up resolution. Next is NCLAT, that is National Company Law Appellate Tribunal. The meaning is the NCLAT is an appellate tribunal established under the Companies Act 2013. It hears appeals against the orders of the NCLT and certain other authorities. That is, the purpose is to provide the specialized forum for speedy resolution of a company law and insolvency disputes. Special courts are designated by the government to try offences under the Companies Act, SEBI regulations and other corporate laws. The purpose is to ensure the quick and efficient trial of the corporate offence like fraud, mismanagement or insider trading. The special court is, in simple words, NCLAT is appellate authority for a company related disputes. Special court is trial court for offences under the corporate laws. Next is company liquidator. A company liquidator is a person appointed to wind up of a company affairs, realize its assets, pay off liabilities and disputes any surplus among shareholders. The powers of company liquidator are to sell the company property, both movable and immovable, to recover debts owned by the company, to operate company bank accounts, to manage the liquidation funds. Next is duties of the company liquidator: convert company assets into cash, pay off all debts, dues and statutory obligations, distribute remaining funds among the shareholders or the members, act according to the Companies Act and other orders of tribunals. These are the powers and duties of the company liquidator. And thank you for giving me this opportunity.